Welcome to Ed Talks. This is an attempt to answer some questions that I get on people that call me off the internet and people that are referred to me. Sometimes I'll get stopped in the courthouse, asked if I'm a lawyer, and a question will be asked. So I'm gonna do a series of these videos to try to answer these questions. And the first question I'm going to try to answer is what I get all the time: is should I plead my case? Should I plead guilty to my case? Should I take a plea bargain? I can never tell anybody to take a plea bargain when I'm not representing them. I can give that kind of legal advice. I don't know anything about their case. So I usually, if I only have a very short period of time, I'll tell them, if you trust your lawyer, take your lawyer's advice. If you don't trust your lawyer, get another lawyer. But that's a bit simplistic. I know what people want to know. How do I make the determination? What do I do to make the right decision? All right, step number one. If you're innocent of the crime, you can't plead guilty. I tell clients this all the time. They'll say, oh, I want to plead guilty, I want to take this offer. They'll say, even though I didn't do it, and I'll tell them, if you didn't do it, I'm not going to plead you. We're not going to plead. That's a no-go. We're going to go to trial and we're going to fight this thing out the way the system is supposed to work. So that's step number one. If you're innocent, you can't plead guilty, so it doesn't matter. It's irrelevant. If you are guilty, if you want to minimize the damage, the danger of a greater sentence, then you need to consider a plea bargain. But what is a plea bargain? A plea offer is not necessarily a plea bargain. A plea offer is a prosecutor saying, I'll do this if you plead guilty. That's not necessarily to your advantage. It's only to your advantage if the offer is a bargain. If it is an offer to punish you substantially less than a jury or a judge would. In other words, in order to prevent the prosecution from having to go through the horror and work of going to trial, you get a substantially better deal than you would get if you went to a jury or a judge. If you went to trial and got convicted, what would a jury do? If you went to trial, got convicted, or pled guilty to the judge, what would the judge do? In determining what a good plea bargain is, you look at two things. If you're a lawyer, you're going to look at two things, and you're going to explain this to your client. One, how strong is the state's case? If the state's case is so strong that they couldn't possibly lose it, you're going to get less of a bargain than somebody where the state's case is weak. It's just that simple. The hardest thing in the world that I've ever had to do is try to convince a prosecutor to reduce a punishment on a particular crime when they have a video of the event to put into evidence. When they can't lose a case, it's hard to have a conversation with the prosecution. Your lawyer can help in that regard, right? Your lawyer can have conversations with the prosecution and try to explain to them why they're going to have difficulty with their case. That may have an effect on the plea offer, on the plea bargain. But generally speaking, your lawyer is going to know how strong the state's case is. The state's going to know how strong their case is. That's going to have an effect on what the offer is. The second thing that's going to have an effect is your background. If you've been to prison, if you've got no friends, you've got no one to speak on your behalf, if you have no employment, if you've been a ne'er-do-well, you're going to have problems on the plea offer that's given to you. It's not going to be much of a bargain. Your lawyer can help with that as well. There's lots of things that people have done in their past lives that are commendable, that they can be presented to the prosecution, and that could have an effect on what the plea offer, plea bargain is. But ultimately, those two things are going to make the final, make the make weighing those two items is going to be where the determination is about whether or not what the plea offer is going to be and whether it's a plea bargain. Why are those two items important? Because the jury will hear about your background. If you're a good guy, they're going to hear that you're a good guy. They're going to hear about from your employer or from your wife or from your kids or your mother or what have you. They're going to know you have no criminal background. That's going to that's going to have an effect on their decision making at punishment. The prosecution's going to know that as well. If you've been to prison, jury's not going to like that. They're going to take that in consideration. It's very unlikely you're going to get less time on a subsequent criminal case than you would the last time. So, and the prosecution knows that as well. So all of that's going to have an effect on the plea offer and ultimately what is a plea bargain. Bottom line, your lawyer should know this. Your lawyer, if he or she has experience, and hopefully what that means is they've tried cases like the one that you have, and a lot of other criminal cases. They have experience either as a prosecutor or a defense attorney or both. They've been around a good long period of time, so they know the judge and they know what the prosecutors are likely to offer. They know what buttons they can push to try to get a better deal. And they have your best interest at heart. If they do, if all of those things are true, listen to your lawyer. And if you don't trust your lawyer, get a new one.